Now that we understand what a deed does, the next question is, when do you actually need one? The short answer is anytime ownership of real property is changing, a deed is required. Let's look at what that really means in practice. Ownership changes are not always sales. Many people assume deeds are only used when the property is bought or sold, and that's not true. Many of the deeds you will prepare as a document preparer have nothing to do with a sale. Ownership can change because of estate planning, marriage, divorce, trust creation, business formation, probate, or death of an owner. Anytime the name on title changes, a deed is the mechanism that makes that change official. Let's walk through some of the most common situations you'll encounter. First, adding or removing an owner. This might be a spouse, a family member, or a co-owner. If the ownership structure is changing, a deed is required. Second, funding a revocable living trust. This is one of the most common deed transactions in estate planning. The trust does not own the property until the deed is properly drafted and recorded. Third, changes after marriage or divorce. Marriage alone does not change the title, just like divorce alone does not change the title. A deed is required to reflect what the parties intend or what a court has ordered. Fourth, are business-related matters. Property may be transferred into or out of an LLC, a corporation, or a nonprofit. Again, the entity does not own the property until the deed is recorded. And last, after someone dies. Property does not automatically move just because a death certificate exists. Depending on how title was held, a deed may still be required to transfer ownership. If title is not changing, a deed is not the solution. A deed that is prepared but never recorded does not protect the new owner. A deed that is recorded late can create problems with lenders, title companies, or heirs. Recording is not an afterthought, it's part of the transaction. As a document preparer, you do not decide whether a deed should be done. You respond to a client who has already decided or who has been instructed by an attorney or court that a deed is required. Your role is to prepare the correct document, ensure it is properly executed, and make sure it's recordable. Knowing when a deed is needed helps you recognize when something else is needed instead, and when a referral to an attorney is appropriate. The big takeaway for this section: if ownership is changing, a deed is required. If ownership is not changing, a deed will not fix the issue. Understanding that distinction will save you and your clients a lot of time, money, and confusion. In the next section, we'll break down the two most important players in every deed, the grantor and the grantee, and why mixing those up can invalidate the entire transfer. Let's keep going.
This video is provided for general educational purposes only. It is not legal advice, and it does not take the place of advice from a qualified attorney. Laws and requirements vary by jurisdiction and by individual circumstances, and watching this video does not create an attorney-client relationship with Nevada Counsel. If you need guidance about your specific situation, you should consult a licensed attorney in your jurisdiction. Thanks for learning with us.